Welcome to Mary Walter Radio, the podcast. How is everyone? Welcome to everyone. If you are new to the channel, please subscribe. And if you have not done so, like the podcast, you can go through YouTube, you can go through Apple Podcasts and Spotify. Please like them if you watch them. We appreciate that. As you know, I am Mary Walter, and that handsome man right there, that is Cully Stimson from the Heritage Foundation. Who better to have on tonight? Listen to this. This man has been a former prosecutor, a former offense attorney, a former judge, Navy JAG, and he is a senior legal fellow for the Heritage Foundation, and he wrote a book called Rogue Prosecutors. So in a day that is filled with a lot of people who are Twitter attorneys, all of a sudden, Twitter legal experts, and sometimes myself included in that, I figured we'd get a real expert on to talk about this and also to take your questions as well. So Cully, welcome. It's great to have you.
Great to be with you, Mayor.
And Cully is one of my favorites from DC. From my time in DC, one of the good things that came of it is I got to meet Hans, I got to meet Cully, and they are just true, real great stand-up guys. So Cully, one of the things we do on this podcast, and I know you've done a ton of other podcasts, I don't have all the bells and whistles everybody else, but we have a really interactive audience. And so they like to ask questions, and they can do that. What we do is I put them up here. Ron and the cat checking in. He says, hello. Yitzhak Dan is back. Chevron Defense discussion in vogue. Let's see. So they're all checking in. So let's start. Let's start with the Chevron defense, and then I want to go to January 6th, and then I want to go with what just came down with SCOTUS that everyone's losing their minds over, and then something that happened today with the hush money case. There are so many moving parts, so hopefully you can just make it very simple for us to understand. So what is the Chevron decision? And it apparently has nothing to do with gasoline as I thought it would.
Well, first off, it's Chevron deference, not defense, but I get why people say that because...
it says deference. I read it wrong. It does say deference.
That's so, okay, yeah. Because, well, the reason that the word defense pops out in your mind, and I think the mind of other people, is because this grows out of a Supreme Court decision from about 40 years called Chevron versus Natural Resource Defense Fund, Incorporated. And in that decision, the court, where Scalia was in the majority, believe it or not, created a rule of deference where they said when Congress passes a statute that arguably has some ambiguities, a agency's interpretation of that ambiguous statute and then implementation of the regulation is entitled to deference by the court. The court must defer to the agency's interpretation of that ambiguous language as long as that interpretation was reasonable. And so what that ended up doing over the decades, Mary, is it essentially took the courts out of the business of interpreting statutes and put a thumb on the scale of the administrative agencies and let them essentially write the rules and fill in the gaps. And remember, not only did Chevron deference apply, but there's a separate layer of deference which still applies, which the court hasn't taken up yet to overrule, and that's called Auer deference, A-U-E-R.
Okay.
And remember, agencies have administrative law judges within their own agencies, and these administrative law judges sit on cases that are appealed up through the agency. And Auer deference, A-U-E-R, requires, the court-created rule again, the Supreme Court and other courts to defer to the administrative law judges' interpretation of the agency's interpretation of their own rules, where they win 95% of the time.
Shockingly.
Right? Yeah. Gee, talk about home field advantage. And so what the court did in two consolidated cases, Loper Bright Enterprises versus Raimondo and Relentless Incorporated versus Department of Commerce, is to say, okay, we're done with Chevron deference. And the reason we're done with it is because under the Administrative Procedure Act, courts must exercise their independent judgment to determine the meaning of seemingly ambiguous laws. Now, that sounds like gobbledygook, okay? That sounds like a lawyer just doing lawyer stuff, and I get paid by the every 6 minutes. I don't, number one. But number two, step back. Put your, you don't have to put your human hat on because you're always awesome. But as a citizen, what was happening up until this moment was the legislative power, the Article 1 power of our Congress, was leached over and bled over and was handed over to the executive branch because of Chevron deference. The executive branch was literally writing the rules. And it got Congress off the hook to write specific legislation. It made it easier to pass laws because they could write sort of loosey-goosey, ambiguous laws. And the agency then, whether it's run by a Republican or a Democrat, would then write the rules the way they want. And then the courts, Article 3, would have to defer to the executive branch's interpretation of the law. So what this has done, Mayor, is this has rebalanced. This has been the best and most fundamental rebalancing of the separation of powers, putting the onus back on Congress to write laws with specificity, taking the executive branch and the bureaucracy out of the business of writing law because they're supposed to faithfully execute the law. And this gets courts back in the business of interpreting statutes and not deferring to the executive branch. And that's the beauty of the separation of powers. You have three co-equal branches of the government at the horizontal level, and then we have vertical separation of powers. This is leveling the playing field. This is getting back to basics. It's a great decision.
Okay, so why is the left so upset about, I mean, they're upset about everything. They're just upset because it's Tuesday. But why are they specifically upset about this?
Well, remember when, let me give you an answer by giving you an example. Remember when Obama said that he didn't have the authority as the commander-in-chief to grant immunity or grant legal status to deferred arrivals?
Right.
And he said, I don't have that authority. It's a congressional authority. Then when Congress didn't go his way, he said, I have a phone and a pen. And he created the DACA and the DAPA program. Now the court has struck those down. And that's because he didn't have the authority. And so when you see things like Secretary Mayorkas issuing guidance, interpreting statutes, when you see, for example, the Biden student loan regulation, which clearly doesn't cover what he says it covers. When you see his wacky definition, redefinition of Title IX, that boys are girls, but you have to pretend they're not boys or something, and that boys can go in girls' bathrooms, all this craziness. What it does is it takes the here's why their heads are exploding, because they are masters of the government. The Democrats, to their credit, are the party of government and the government bureaucracy. They know the weeds. And so they know how, and because a lot of bureaucrats are left-leaning, they know how to manipulate and tweak the rules in a way that inures to the executive branch of their favorite flavor, Democrat, advantage. And so what this does is it just says, look, you don't get the preferred thumb on the scale deference anymore. The courts are going to see whether your interpretation was reasonable. The courts are going to determine what a statute says. You don't get to interpret it.
Gotcha.
That's good.
So is this, and I agree. So is this part of, and then there's a bunch of questions coming in for you. Like I said, we've got great viewers. They ask a lot of really great questions. Some of them not so smart, but some of them are good. Is this part of dismantling the unelected bureaucratic branch of the government? It's almost become a fourth branch of the government that's more powerful than the other three branches of government. Is that part of the slow dismantling of that?
This is a decapitation of that.
Oh, I like that even better.
In the figuratively speaking, because the problem with the so-called fourth branch of government is that there should be only three. Right. There shouldn't be a fourth branch of government.
Right.
Right. And the fourth branch of government has been this sort of kudzuization of the executive branch within the bureaucracies, accruing more and more interpretive functions to themselves, and then having this sort of belt and suspender of Chevron deference and then our deference for the administrative law judges on top of it. And so, look, I put the blame on Congress just as much
100%.
as I put on the executive branch, because when you have a 3-day work week, you come in Monday and you leave on Thursday, and you're dilly-dallying and you're not passing laws with specificity, you're not working the committee process, and you're leeching your powers over to the executive branch so you can pass loosey-goosey laws and then let them fill in the rules. They have been ceding their authority for decades, not just because of Chevron, but because that's their want, to the executive branch. And the executive branch, both parties, are like Pac-Man. They'll take as much authority as they can get. And what the court said in Loper, Bright, and Relentless is, we're done with that. This automatic deference that you get, we're done. Courts are in the business of interpreting statutes. You're done with that. We're not giving you any deference at all. And so, in theory, and Mary, change is hard in Washington. In theory, what's going to happen is Congress is going to staff up and bring more staffers in. That means the government's growing. And they're going to be more specific in the writing of their laws. That and a quarter will get you a gumball. I'm not sure that's going to happen overnight. That'll take time. And it'll take a series of other decisions, in my opinion, for the court to say, hey, we actually meant that. And sorry, you weren't specific. And that law is vague, or that law is this. And we're not going to defer to the executive branch's interpretation of that.
So much lawfare. All right, let's get to, because there's so much to talk about, and I know you want to get barbecuing.
No, I'm good. I'm good. Apparently, I can hear them already leaving me behind. So I'm.
Oh, I'm sorry.
I'm all yours.
Okay, so Ron wants to know: can or will the Chevron ruling be used to roll back climate change overreach? Anything from gas stove restrictions to EVs to offshore wind to whatever.
Yeah. So I'm allergic to cats, so I refuse to answer his question. No, just kidding.
Well, I've got 3 of them right here.
I am
waiting for me to feed them.
Yeah, my nose is getting itchy just listening to you. So I think, I hate to be lawyerly, it depends. If the restrictions, so-called restrictions, came as a result of a creative interpretation of a statute or an abusive interpretation of a statute or something made up out of whole cloth by the executive branch, absolutely. But now remember, these things aren't self-licking ice cream cones, and so they're going to have a plaintiff, and the plaintiff's going to have to sue. That's a DOD term. And the plaintiff's going to have to sue, and then it's going to have to go through the courts unless the administrative agency or the executive branch just withdraws the regulation. That's not going to happen. I have a better chance of playing in the NBA at 5'8" than at a 60-year-old guy than the administration withdrawing these wacky interpretations, because this is their policy preference, right? This is what they can't get done in the legislative side, they're going to try to do on the administrative side.
Right. Okay, so it's a game. It's just a game. Everything's a game in Washington.
Well, it's a serious damn game, right? Because every time extrajudicial or extra legislative things happen, we lose our liberty, right? We're only giving the government the amount of power that they should have, and in theory, nothing more. But when they're out there getting beyond the people's representative, the legislators, and creating law, we didn't authorize that. And so we lose liberty every time they do that.
100%. Dan says, in the congestion pricing litigation, NEPA, the soft underbelly of the EPA fiat, is being used to defeat the decision to go ahead with the pricing rules. To the whales and windmills, success seen. I have no idea what that means, but maybe you do.
Well, if I understand his question, it's a version of the first question, and that is, does the Loper, Bright, and Relentless decision put pressure on or undercut the very legitimacy, and I use air quotes, of these EPA fiats that go well above and beyond anything in the standard legislative language. So I think you're going to see a lot more litigation. And of course, that was the laughing part of the dissent. Oh my gosh, there's going to be more lawsuits. Oh, isn't Washington already littered with lawyers? I mean, we have enough lawyers to, sink 10 Titanics in Washington, D.C. alone. So, you're going to see more lawsuits challenging extrajudicial or extra legislative pronouncements by the executive branch, Republicans and Democrats alone. And the courts are going to have to do what courts should have done in the first place, which is to reclaim their judicial authority.
Yeah. Sue's Love Jess says, Happy Independence Day to you and yours. Watching your back. So what's to prevent the agencies from ignoring such SCOTUS rulings? I mean, the ruling on student loan debt is all but being ignored.
Well, it's sort of a philosophical question, but also a practical question because, Biden has already thumbed the nose at the Supreme Court on his student loan debt first ruling. I guess the ultimate check on the abuse of authority is either at the presidential level or for cabinet appointments, impeachment, or losing at the ballot box. But I think on a micro level, lawsuit after lawsuit after lawsuit, where organizations in the public interest, freedom-based public interest legal movement will just file lawsuits and keep beating them. And by the way, Pacific Legal Foundation, ADF, and all these great organizations that are out there that I hope folks support are winning. They're not going to get tired of winning, to quote somebody, but they keep winning before the Supreme Court because they have the law on their side. And Loper Bright and Relentless give power back to the people. And they force the three co-equal branches of the government to stay in their lane. That's key.
Right, that is. Dan says, I love the Chevron defeat, and I'm a tree hugger. And passed Pace Law environmental moot court judge.
Great. I love trees too. The conservative movement and the conservation movement started with conservatives because we love the environment. TR obviously started the national parks out there. So I think anybody who's an honest broker, liberal or conservative, should applaud the rebalancing and resetting of the three co-equal branches of the government in this decision. The people who don't like it are political actors who want the executive branch to do what can't be done through legislation.
Right, exactly. They want, a dictator who just rules by executive decree. The irony of it, isn't it? Dan, now will the ABC agencies be forced to give up their guns, literal guns and ammo? Like, why does the IRS have an armed part of their agency? Like, why are they now carrying guns? Why?
I've had the privilege of working for some amazing people, including Don Rumsfeld, Bob Gates for a short period of time, and Ed Meese. I work in the Meese Center at the Heritage Foundation, and Ed Meese said to me a long time, because I asked him a version of this question, why does the XYZ agency have a SWAT team? Right. When they're dealing with sewers or dealing with trees. And he said, retirement benefits. And I said, what? And he said, once you get a law enforcement arm in your agency, you're eligible for a different retirement scheme in the federal government, and it's a better pay. And I said, oh, come on, Ed. He said, yeah. Now, I haven't given it much more thought than that. And I think, obviously, you want a honest, hardworking, and for the most part, most field FBI agents are honest and hardworking folks. I know a bunch of them because I was in the AUSA and a state prosecutor. You want the ATF to exist and stay in their lane. But to your point, does the IRS, does the Forest Service, does the fill in the blank agency need a SWAT team? I don't see the need for that. But of course, have Republican Congresses tried to defund them? Have Democratic Congresses tried to defund them? I mean, name one federal program, Mary, that's been cut. I challenge your listeners to name one.
Never. Dan goes on. Dan must be in Jersey because Governor Murphy here in the Socialist Republic of New Jersey is plowing ahead with windmills, all without final EIS findings and hearings. Can the decap SCOTUS decision stop the windmills and save the right whales? We have an extinction event. It's true. They're washing up on the shores all over the place.
Yeah, I don't know. I don't know the answer to that. All I can tell you, because I haven't studied that issue in particular, and I just don't know the answer to that. But I can say, in general, this decision will have reverberations across not only the federal government agencies, but I predict state government agencies for decades to come. And it's a massive step in the right direction. It's, in my opinion, the most important decision in the court term this year, more important than Trump.
Wow, so interesting. Because I didn't know that, so I'm really glad we're doing this. Let's see. Hermit Sal brings up, he says, I once heard that agencies like the FBI can create administrative warrants and then go to a judge to review the legality of that warrant after they execute it. Does that still continue?
Not to my knowledge, no.
Okay. I'm sorry, we're behind in the comments. Porchview Farm brings up the IRS. Scott says, this show's going to be interesting. Dan brings up NEPA litigation has been brought against the windmill BOEM decision. What chances do you see for you said you didn't know anything about that, right?
Right. Dan's very consistent.
He
Dan
is.
has nothing on his mind. I applaud Dan. Good for him.
When you made your comment about being 5'9" or whatever, Barry says, hey, if Bronny can play in the NBA, anyone can. Good luck, bro.
Yeah, I don't think I have the same DNA as Bronny. I hate to admit that. But hey, Muggsy Bogues could jam. He was 5'4".
There you go.
I think I can still touch the net, Mary, but I think I'd have to recover for a week. Just saying.
All right, let's move on to January 6th and the enhancements ruling. So there's a lot of people sitting in prison right now in the January 6th prisons. Is it true that there are still people behind bars sitting in a room somewhere being thrown into a little cell that still have not had court dates yet? Do you know?
I don't know. I will tell you, in the interest of full disclosure, that I was an AUSA, an assistant U.S. attorney in the D.C. U.S. Attorney's Office, which brought all these cases. And I have some former colleagues who worked on those cases, and obviously they're not going to violate their oath and talk to me and tell me anything about their cases. But I will say, with respect to the Fisher against the United States decision, which was a 6-3 decision by the chief, that in holding Section 1512C2 of the Sarbanes-Oxley Act, which remember came out of the Enron scandal, that it only applied, it prohibits impairing or attempting to impair the availability or integrity of things that can be used in an official proceeding, and that really grows out of the type of Enron type things. Some of these people who were convicted and some of these people who have been sentenced were convicted only of that charge. And so I would think in very short order, I would hope before the 4th of July, this week, the Justice Department will dismiss those cases forthwith. And if I was the defense counsel, I'm sure right after, and I know some of the defense counsel in these cases too, because there's a small legal world in DC. Yeah, we all know each other. I would think the defense counsel immediately filed a petition for withdrawal before the court, and the court could, the district court judges could grant forthwith a finding of not guilty and order them released from custody immediately.
So where do these people go to get their lives back? These people, the enhancements, especially the people who were charged only with this, the charging, you can't tell me that they didn't know, the prosecutors didn't know what they were doing when they did this. This, to me, in my humble opinion, and I'm not a lawyer, but I watch a lot of Judge Judy, in my humble opinion, this was lawfare. This was sending a message to anyone who supports Donald Trump that we're coming for you, we're going to get you. And these people's homes still being raided not that long ago because they showed up on January 6th. And there's a grandmother in jail right now. She has to serve 4 months. She's 70 some odd years old because she walked through an open door into the Capitol, She didn't destroy anything. She admitted to being in there for about 10 minutes. You can see her on video. They released the video. She said a prayer. She said, I said a prayer for the country. She spoke to a, quote, very nice Capitol police officer and left. But yet she has to do 4 months in jail. When there are people in, the summer of love, there are people, look what just happened in Washington, D.C., where they were defacing all the monuments and everything because they didn't, because they were pro-Hamas demonstrators. And not one of them is arrested. So you can't tell me that these prosecutors in DC are just so they just don't know the law. They're just so overzealous that they accidentally charged all these people like this and accidentally raided their homes and accidentally put them in handcuffs and paraded them in front of their neighbors, and they accidentally lost their jobs and their homes and everything else. Oops, or bad. Now what?
Yeah. One of the things I learned early as a lawyer, Mary, is that you can never put a criminal defendant or victim, for that matter, back in the same place they were in prior to the incident happening. It's not like civil money damages where at least money is supposed to make you whole. There is no making whole in these types of cases. That's the first point. The second point is the U.S. Attorney for the District of Columbia, Matt Graves, is a disgrace. He should have resigned a long time ago. And that comment has zero to do with these January 6 cases. But those cases make it worse because he has not only allowed crime to metastasize and grow in the District of Columbia, he has disbanded the community prosecution unit in the District of Columbia. So prosecutors who were stationed all around the city doing community meetings, hundreds of them a year, he brought them back into the office, and they're not doing any community meetings. So he's not even listening to community. Third, he doesn't take gun crime seriously at all. So when you're a felon and you're caught in possession of a firearm under federal law, you can take that person to federal district court and prosecute them under 18 U.S.C. 922G. That's felon in possession of a firearm. Everyone knows that. Every U.S. attorney's office around the country does that except Matt Graves. And every single day, Mary, in this city, everyone knows who the bad 200 dudes are. Every single day, those guys are caught in the city with a handgun. And what does he do? He doesn't take them to federal district court. He takes them to the Superior Court for the District of Columbia. He waters it down, and they get probation, and they walk out the front door, and they go commit more crimes. And I have it from inside sources in the office that he's diverted all the attention from the real gun crimes and the real blood and gut stuff to these J6 cases.
Yep.
And so I'm sure, because Graves isn't the brightest bulb in the light bulb store, he got direction from on high that he had to be creative. And I'm sure people at Maine Justice were pushing this 1512C2 really wacky interpretation of the Sarbanes-Oxley law. He should resign. He's a disgrace. We need a real prosecutor in this city. And I never thought that this charge was a charge that was legit. The Supreme Court now has said it's not a legit charge. Every single person who was convicted of that should not only get exonerated off their record, but anyone who's in jail solely as a result of that should be out yesterday. And if they're dragging their feet and they're not out of yesterday, it's because they want them to stay in a little bit longer.
Yep. And there were people who committed suicide over this.
Right.
With the enhanced charge, because the enhancement took something that was just like a misdemeanor, parading. And parading's nothing, but because of the enhancement, they were raided, they were paraded in front of their neighbors, all this other stuff.
Right.
And their lives were ruined. Families wound up homeless because they lost their jobs. That blood is on someone's hands. And I find it hard to believe that there is no recourse for these people to at least get a pound of flesh back for having their lives ruined. Well,
I don't know about a pound of flesh. I doubt that they'll be able to sue and get any money damages for it. And to your point, there needs to be a public reckoning.
Yes.
Now, let me be clear here. And I know you and I are of the same mind on this, and we've never talked about it. Anyone who committed a violent crime on any day in the city, including on January 6th, should be held criminally accountable. That's obvious. We take that as a given. We have to say it in this type of hyper political world. But trespassers, people who want to go and talk, walked in like this grandmother that you're talking about, give me a break. And
Yep.
there's a lawsuit, there's a website out there called Lawfare Blog that I used to be a contributor for. And they had a running list of all the people charged and all the charges of every single person charged and prosecuted in J6. And when I went through that a while ago, when they first came out, the vast majority of them were trespassers.
Mm-hmm.
And here, this same U.S. attorney, who is a disgrace, who should resign in disgrace and never be seen in D.C. ever again, he won't prosecute thieves, shooters, violent 17 and 16-year-old homicide victims get to stay in juvie court instead of prosecute them as adults for their adult conduct. He won't take gun crime seriously, yet he's going after 70-year-old grandmas who are wrapping themselves in the flag and sort of trespassing at the Capitol. Matt Graves is a disgrace.
Well, Matt Graves is going to probably retire with a nice fat pension that I'm paying for. And those January 6ers taxes are going to pay for as well. And the system needs to be blown up because there's no way to hold judges accountable for these decisions. Judges who let these illegals go time and time and time again until they finally murder an American, then we pay attention to them. So there's got to be some kind of, there's got to be a mechanism. The system has to change. They should not be unaccountable to anyone. There has to be some way there has to be some system of punishment for judges like this who engage in what is seen as, I think, malicious prosecution on one side, and then letting criminals go on the other hand. There's a two-tiered system of justice. That's not their job. They have to be held accountable in some way, shape, or form. And if the only people accountable for a judge is other judges, well, in DC, that doesn't work.
We wouldn't be having this discussion, Mary, if a rational, reasonable, pro-law enforcement, pro-victim, pro-cop prosecutor in DC filed charges against the people on January 6th who committed violent crimes and had no defense and didn't charge anyone else. We wouldn't even be having this discussion because who isn't for holding violent criminals accountable? We all are, at least people on this side of the people on earth here. But that's not what they did. They threw out a dragnet to make the grandma you're talking about look like the Unabomber.
Exactly.
And that is an abuse of prosecutorial overreach and discretion. And by the way, no other person who trespasses and walks into prohibited areas on the Hill, which happens every day, by the way, gets prosecuted. They get a warning. The police officer says, "Oh, you shouldn't be here. Please turn around, ma'am," and walk out. And so this has been hyper politicized. I understand why people have politicized this. I think the people that destroyed property and assaulted police officers and committed crimes are criminals. They have the presumption of innocence, but they should be held accountable. But this was used as a political tool to gin up angst.
Yep. And people like Ray Epps, who urged people to go into the Capitol and trespass and commit crimes, doesn't spend a night in jail. So weird. Just saying. Porch View Farm says, my brother-in-law. Now, we all know about her brother-in-law. He's very liberal, okay? So we know. He's disrupted the Supreme Court, sat in numerous senators' offices, stopped traffic all over the country, and rarely spends a night in jail, of course, because they don't take him seriously. Dan wants to know, can the J6ers bring a Bivens case or Manel?
So a Bivens case is named after a party in a Supreme Court decision, and it is a case that deals with bringing tort suits against federal officers who commit torts against individuals. I don't know the answer to that.
Okay. He said, or a 1983 case. He also asked that.
Yeah, that's a civil rights action case.
Okay.
And I don't know the answer to that because I haven't studied that either.
Yeah. He also said Garland is still tracking people from J6 through cell phone records, etc. Can he be made to stop?
Well, if he quits, or if he gets impeached and removed from office, or if they defund the Justice Department, which I know that they're trying to defund aspects of the Justice Department, not the whole Justice Department, obviously. But, Garland has withstood withering cross-examination and oversight and posture hearings, and he still remains in office, and he still enjoys the privilege of being the Attorney General.
I'm a big fan of karma. That's all I'm going to say. I do. That's big.
Well, you're a Catwoman. You're a Catwoman, Mary. I mean,
well,
thought we were friends, and now you tell me you're a Catwoman.
Well, I grew up having dogs, but now we don't live a life to have dogs. So we got cats.
I'm a doggy. See, I'm a doggy person right here. See that? Look at that beautiful doggy right there. Yeah,
that's cute. That's cute. Mine all ran. One of them fell off the table, and they all ran. So I don't know where they are. But anyway, okay. So let's talk about the ruling that everyone is absolutely hair on fire. The left has set their hair on fire over what just came down from the Supreme Court about immunity. Now, I love telling all of these little libs on Twitter. I love going after them. And I say things like, well, you know, if the Democrats hadn't weaponized the federal government to launch a lawfare campaign against a political opponent in order to interfere in an election, we wouldn't be here right now. So they're the ones who forced this to happen, and now they're not happy that it happened. So now, of course, to save democracy, they want to dismantle the Supreme Court to save democracy, because they're all insane. Their brains are broken. I'm 100% sure that their brains are broken. I don't understand. You have Sotomayor saying that that if a president orders the Navy SEALs Team 6 to assassinate a political rival, immune. Organize a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, immune, immune. And then you have Ketanji Brown Jackson, that brain surgeon, jumping in here. And she goes on to say that he could, what did she say he could do? Oh, he could, if he talked to a member of his cabinet and had them assassinate a political rival, none of that conversation would not be able to be brought into court, and he could get away with it. How could they're supposedly the 9 of the smartest legal minds in the country. Although, to be fair, Ketanji Brown Jackson doesn't know what a woman is because she's not a biologist. So, you know, I kind of doubt. But they're supposed to be that. How can they read that this way? How could they get it so wrong?
I know what a woman is because I married one and I'm talking to one. But
don't you dare assume my gender.
I did, and you're a lovely one at that. Look, let's go through a couple of those hypos. All of which are ridiculous.
Right.
I served in the Navy for 30 years. I was I was in the Judge Advocate General's Corps. I was a Joint Special Operations Task Force JAG, and I deployed to SEALs. I can guarantee you that if a president ordered SEAL Team 6 to assassinate a political rival, they would refuse to carry out the order. Not only would the JAG, who advises them, tell them that is an unlawful order, but they have brains. Okay, they're officers and senior enlisted with serious understandings of the law of war and law of armed conflict. They're not going to do that. These other hypotheticals are absurd. Look, this wasn't a decision about Trump. I know the title is Trump against the United States. This was a decision that clarified and illuminated the unique role that the president has in our constitutional republic. And it didn't give a full and complete victory to this particular plaintiff, President Trump. It clarified with very, I would say, conservative, nuanced language that, and I want to be specific, that the president enjoys absolute immunity for actions taken within his conclusive and preclusive sphere of authority granted to the office by the Constitution. So think pardons, okay? The president has plenary, that means absolute authority to issue pardons no matter what Congress says. And presidents enjoy, quote, at least presumptive immunity for all other official acts. The opinion then says presidents are not above the law. That's a quote. So it would be above the law to order SEAL Team 6 to assassinate somebody. Be above the law. It would be an unofficial act to do all the things, the parade of horribles that the dissent talks about.
The parade of horribles. I love that.
It is. And this is the other thing the opinion says. Roberts explained that in determining whether there's immunity, quote, the first step is to distinguish a president's official from unofficial actions. Yet he made clear that in this case, quote, no court has thus far considered how to draw that distinction in general or with respect to the conduct alleged in particular. That's because the unprecedented nature of this case and the very significant constitutional questions it arises, the lower courts rendered their decisions on a highly expedited basis. That's why he sent it back. So there's 4 buckets of stuff in those indictments against Trump. Bucket 1, the conversations he had with the Justice Department. He's absolutely immune from that because he is the chief law enforcement officer of these United States. But the other 3 buckets, let me go through them here. The discussions with the vice president, every single 8th grader studying social studies needs to read this opinion, not the dissent, but the majority opinion, because especially the parts in pages 30 through 35 about the role of the vice president, it's a unique role. It's not a warm bucket of spit. It is the number 2 in the executive branch and the president of the Senate. So not only do they have executive branch responsibilities, and those conversations between the number 1 and number 2 are clearly protected, but legislative authority as the president of the Senate. But then they have this sort of hybrid role. So if they called in to cast the tie-breaking vote for an administration nominee who they want, that's clearly the executive branch function exercising his role as the president of the Senate to cast a tie-breaking vote. So you got to read about that. So they punted that back down to the district court. They punted, for example, the conversations about the electoral slates in states and other election-related issues. Now, he was the president when he was talking to the folks in Georgia, right? And then the 4th bucket is the conduct, mainly tweets and public statements he made as president on January 6th. And so they didn't say, he wins, you lose, go away. The court was very nuanced. They used a very, very sharp, tiny little scalpel. And they said, okay, discussions with the Justice Department, absolutely immune. All the rest, presumption of immunity, but there's no factual record here. Send it back to the district court, which is the place where facts are developed. And you guys use these guidelines and sort it out. So what's going to happen, Mary, is the district court judge is going to have to spend a lot of time and actually do their job. They're going to have to roll up their sleeves, get counsel in there, put evidence on, and then decide on an act by act by act by act basis. Official, that falls in the conclusive reclusive sphere, or official that has presumptive immunity. And then if it doesn't, then is it unofficial? And if it's unofficial, then he can be prosecuted. And if you listen to the oral argument, I guess the liberals weren't listening.
Shocking. Well, they're too busy screaming.
Amy Coney Barrett asked Trump's lawyer, this is a Harvard Law School Rhodes Scholar. Okay, this is alleged indictment. Is this official or unofficial? He goes, unofficial. She goes, this act, official or unofficial? He goes, unofficial. He admitted on the record. The court talks about it in the majority opinion. There are things, alleged indictment, that fall into the unofficial category. Now, there are other things that are going to get knocked out from the very beginning. So we got a long way to go here. And the district court's going to make findings of fact and conclusions of law. The loser will clearly appeal to the DC Circuit. It's going to go back and forth there. There's no way in heck that this case is going to be heard on the merits and there's going to be a trial this year. Period. Not going to happen.
No. And well, let me ask you a question. A lot of people asking these questions, so I'm not putting each individual question up on the screen in the interest of time.
No more cat people. No more cat people. We can't have that.
Well, Shirley and Oliver are right here, and they want to be fed. So I know how to take you out, and no one will ever know.
Oh, I'll know now. I'll stick Mac Graves on you.
So let me ask you a question. One of the things I've been saying also on X, and correct me if I'm wrong, because I'm being a Twitter lawyer, is if the ruling had gone the way the left wanted this ruling to go, then when Joe Biden leaves office, he could be held liable then for the deaths of the 13 service members at Abbey Gate, right? He doesn't have immunity for that official act.
Actually, it'd be worse than that. John Yoo, YOO, who I know you're aware of, and I wrote a piece in Newsweek a few weeks ago, which you can put in the show notes if you want. And we talked about the Bragg decision and Bragg prosecution in New York and the Georgia prosecution by Fannie I Hired My Lover Willis. We say, what now exists that would prevent one of the 2,300 elected district attorneys around the country, when Biden leaves office, especially, let's say, a Republican DA in Texas, from filing manslaughter charges against Joe Biden for his policies that had the clear and obvious natural consequence of causing the deaths because criminal aliens came across the border and killed people in their state. And we listed a whole series of other potential charges that a state court prosecutor could bring against Joe Biden for acts he took while he was in office, but they waited until he was out of office. So when normal people back here on Earth read the Trump versus United States decision, and Biden, somebody can explain to him when he wakes up tomorrow afternoon that this decision actually helps him and insulates the office of the presidency for their official acts. Look, we can have policy differences in this town. I mean, I don't agree with any of Biden's policies at all. But I think this decision will preclude the prosecution of current and future presidents for their official acts, and they'll enjoy the presumptive immunity for all other official acts that they've always had. This is the aberration, going back to your initial point. This period of time is the aberration. So this court is simply putting on paper what we knew to be true until this time.
Right. So the last one thing I want to say, you brought up Fannie Willis. I don't know if you saw Bob Menendez, New Jersey, his defense of why he had all the money in the gold bars around. It's the Fannie Willis defense. It's cultural. Did you see that? Fannie Willis says she had all this money around because her father always told you have to keep cash and all that. They said it's the same thing. Their father told them that because when they fled Cuba, they only had the money that they had hidden in a clock. So that's why he had money everywhere. I was like, oh my gosh, I love it. He's using the Fannie Willis defense. This is awesome. I love that.
Let's see. I know a lot of Jersey people, and let's see if any of those jurors buy that.
Oh, they will, because the first time around he got off. So 100% they're going to buy it because they love him. They love him. So last thing is we now have Judge Merchan, now delaying Trump's sentencing till at least September 18th in light of this ruling that we're just talking about now.
Yeah.
Why is that? Because they brought in, he had Hope Hicks on the stand. He had other members of Trump's inner circle. There were social media things put out from when Trump was president. There were phone logs, text messages, all that kind of stuff from when Trump was president. So is that what's happening here, that a lot of this may just get all thrown out along with these 34 counts?
Well, I now grant to you your honorary law degree, and don't call yourself a Twitter lawyer, call yourself a C lawyer. That's what we Navy people call people who pretend to be lawyers and just pontificate. So you're a C lawyer, SEA, C lawyer.
I don't think that's a compliment.
It is a compliment. It's a great deal. You're awesome. And at least you give you your partial law degree. So you're right. I think number one, there's a more practical reason why he continued it, because the defense and prosecution both agreed. The prosecution agreed to the defense request to continue the sentencing. So once both parties say, will you please, once they roll over and play dead and say, we want to continue it, to consider a late development from the court, the judge is going to have to agree to the delay. Secondly, we don't know what will be in the pleadings that the defense team will file, but you're absolutely right. one of the aspects of this opinion, and I would direct your loyal audience to page 7 of the opinion or pages 30 through 32 of the majority opinion, is they said testimony or private records of the president or his advisors probing such conduct, criminal conduct, may not be admitted as evidence at a criminal trial. And so, nor can they look at the president's motive. Now, he was charged and convicted of activities he did before he was the president. But to your point, at trial, they used people and evidence and documents and other things that were created while he was the president. And so it's going to be very hard to unspool that thread and pull out this and this and this and this and this. You couldn't have considered this. The jury couldn't have had that. The jury couldn't have had that. Some judges may say, look, I'm not going to sit here and pull out all these little pieces of this trial and then pretend the jury would have convicted. I'm just going to order a retrial, which could happen. It could happen. Marshawn could double down on stupid and just march forward with the sentencing, despite the fact that he didn't recuse himself, didn't grant the motion of change of venue, the stuff with his daughter, all the other things he let in, all the way he had his thumb on the scale throughout the whole trial, which we've written about at the Daily Signal, which we as lawyers think that he didn't conduct the trial in a fair and orderly manner to the defense. He could double down on stupid and then just march forward with sentencing, and the defense would immediately take up an expedited appeal on that. Or, depending on what the pleadings say from both parties, especially the defense, he could say, look, in an abundance of caution, I'm going to order a retrial. Or, I rule that these charges, for whatever reason, can't be rebrought, and here's why. And of course, the government may want to try to appeal it. It's a mess. It is a complete and utter mess. It's the Lawyer Full Employment Act for sure. And I wouldn't be surprised if the sentencing doesn't take place at all.
So can they still call Trump a convicted felon if he's never sentenced?
Yes.
They can. I thought they couldn't call him a convicted felon until he was sentenced.
Well, there's a difference between just using it as a non-lawyer, as somebody who got convicted, versus whether somebody who got their sentence and as a legal matter, he's a convicted felon. But they're using it as a political cudgel. That's the reason. That's the way they're using it. They're not using it as a legal nicety.
Right. Okay. Let's see. Wait. Now, hold on. Sal says this evidence stuff sounds like both and neither at the same time.
Yeah. Welcome to law school. That's right.
One other quick thing in that going back to the immunity decision, Thomas put something in there. I think it was only one sentence, though, questioning the legitimacy of the appointment of Jack Smith. Did he not?
Yeah. So Justice Thomas wrote a concurrence, but he's really picking up on one of the amicus, which means friends of the court briefs filed by my boss, Ed Meese, and Attorney General Michael Mukasey, that really brought up a collateral but important issue, and that is, we don't think under the Appointments Clause that Jack Smith was properly appointed. And in fact, the Attorney General does not have the authority to appoint him as special counsel. And they explain for technical, legal, and constitutional reasons why a special counsel must be nominated by the president, confirmed by the Senate, and appointed by the president. And so, just what Justice Thomas said is, look, before you all get to the other stuff that the majority is talking about, I want you, district court, to sort through the more fundamental issue, and that is whether Jack Smith is even eligible and properly appointed to serve as special counsel. Now, just like the Chief Justice said a long time ago in a decision, which I thought was awesome, that litigants should not take legal advice from dissenters. And that was in the Students for Fair Admissions versus Harvard decision, where the dissenters were saying, boo hoo hoo, you can't use race in admissions anymore. But at least the service academies are allowed to use race in admissions. But footnote 4 of the majority opinion that Justice Roberts authored said, the service academies were not before the court, so we're not going to answer the question with respect to whether the service academies can or cannot use race. And then when the dissent said, oh, the service academies are exempt, Roberts goes, people should not take legal advice from the losing party. And so because Thomas's point about the appointments clause was a concurrence, I think that the district court would be prudent to bring it up and try to answer it. But they could ignore it because it's part of the concurrence and not part of the majority opinion.
Yeah, and
It'd
this
be
is
unwise to ignore it.
But this is part of Eileen Cannon's question, which she's in Florida that she's dealing with right now too.
Yes, she's taking it up.
She's taking that up as well.
Yeah.
So all right, I'm going to let you go get your barbecue. Thank you so much for your time. Cully Stimson, you can follow him on X at Cully Stimson. It's pretty easy. And your writings and Hans von Spakovsky and the rest of you all at the Daily Signal. You are there. And I will look for the link to the piece in Newsweek with John Yoo, and I will put it up on the YouTube and on for all the other podcasts, so you can catch that as well if you want to go listen to it on Apple Podcasts or Spotify. The links will be there for you. The book is Rogue Prosecutor or Prosecutors?
Rogue Prosecutors, How Radical Soros Lawyers Are Destroying America's Communities. And it's available on Audible as well, and at Barnes & Noble and Amazon.
There you go. Where you buy your fine books. I remember we had you on the show when that book first came out, if I remember correctly.
It was awesome. Thank you very much. Appreciate it.
I remember that. Let's see. Dan Byer says, this awesome. This has been absolutely awesome. They love you. I can't put them all up because I want to let you go get your barbecue. But Gregory says there seems to be a lot of malfeasance by these prosecutors. Can't the bar associations do anything? They can, but only if they want to, right?
So our book is a true crime novel focusing on 8 cities with 8 of these rogue prosecutors.
Yes.
And when we wrote the book, which came out last year and was in the top 10 on Amazon and law enforcement for a long time. So if you go out and buy it, push it back up. We had Chesa Boudin in San Francisco. He's been recalled. We focused a whole chapter on George Gascon in LA. He's has a tough general election coming up this fall. Hope he loses. Kim Fox, who's the first rogue prosecutor in Chicago. She's not rerunning. Remember right. Jussie Smollett, the Jussie Smollett disaster?
Yes.
She's still in office, but she leaves this year. Kim Gardner in St. Louis, she resigned in disgrace. Right. She was not qualified to be in the office in the first place. Then you had Rachel Rollins in Boston, who resigned in disgrace under an ethical cloud. Then you got old Alvin Bragg. There's a whole chapter on him and why he really is not a prosecutor's prosecutor like he should have been. And he ran on, of course, the promise to go after Trump, but there's a lot worse stuff in the chapter about him. Really, the most evil of all of them is Larry Krasner.
I was going to say, I was waiting for you to say Larry Krasner.
Well, because he's slick, he's serpentine, and the criminal element loves him. In fact, his nickname in Philly is Uncle Larry. That's what they call him.
Wow.
And we have a whole chapter on him, and I just have this piece up in the Daily Wire about him because the Pennsylvania Court of Appeals gave him a big slap in the face last week. And then, of course, there's old Marilyn Mosby, who was convicted in 2 different federal trials, one of mortgage fraud and one for lying. And the Maryland bar only suspended her license. And she wants a pardon from Joe. So she's out of office because the voters in Baltimore, all Democrats, said enough is enough because she not only boffed the Freddie Gray trials, but also crime exploded in her cities. And so this social experiment is failing. 73 of the 2,300 elected DAs across the country are Soros bought and paid for, accounting for 68% of the population of this country. 1 in 5 people live in a Soros DA city. And so people need to wake up. Just like we learned the hard way, Mayor, that who you vote for your school board directly affects your kids' education. Who you elect for your DA directly impacts your public safety, period.
Yeah. But, you know, and there's a lot of them who are still going to keep doing the same thing over and over again. And I said that on the radio today. I have a hard time. I was on in Baltimore and I'm like, I have a super hard time feeling sorry for you. You keep voting for the same thing over and over again. Maybe you personally don't, but everybody around you does. So if that's the way they are and they can't learn, they haven't hit, they're like alcoholics. They got to hit rock bottom, like drug abusers. You got to hit rock bottom. And maybe when it unfortunately comes to you is when you say, wow, I guess crime is really bad.
I feel really bad for the people that voted for these people because crime is geographically and demographically concentrated in inner cities. 90+% of victims of homicides are by black males. 2% of 2% of the counties in the country have 50% of the murders in this country. And so George Soros and Dustin Moskovitz and Carrie Tuna and the rest of them who funded this movement, and Soros has poured $50 million of direct spending into these races and about $1 billion in indirect spending, have pulled the wool over the eyes of the most vulnerable communities. And they're finally waking up to the horror and carnage this has caused. But you can't, to your point a long time ago, undo the damage that's been done. And so this movement can't fail fast enough. And when people read our book or listen to the Audible, they're going to realize through real crime stories that, but for the policies of these pro-criminal anti-victim zealots, would not have happened. And that's why this needs to fail.
No, absolutely. And I think it is. I think the pendulum's starting to swing back the other
Yep.
way. You're starting to see it. And they hate that most of all. That's why I think they're fighting so hard. And I think that's why Joy Reid doesn't have any hair, because she lights it on fire on every other day, because something's not gone her way. So, but I think, like I said, I think we're kind of the addicts are starting to hit the bottom and come up the other side.
Well, look what's happening. Look what's happening in Europe, right? The populism and nationalism is winning the day. Marine Le Pen's party got 33.5% of the vote. Yesterday on the 7th, people are going to put her in power. They're going to take the prime minister position back. That's happening in Italy, Spain, Germany, Denmark, Belgium. It's happening all across Europe. The only place where it's going left back to socialism is the UK and Warsaw, and they're going to regret that.
Yep. But what did the left do in response to losing? What do they do everywhere when they lose?
They're like kudzu.
They rioted.
Right.
They rioted.
Hope not. Well,
in France, they did. In Paris, they were rioting. They were marching through the streets, throwing, with explosives and this and that and everything else going on. But that's what they do. Ron, by the way, is very impressed with you. He said, all this and no teleprompter.
There is absolutely no teleprompter here. It's all right in this little Hungarian Irish brain.
You should run for. See, I like the Irish part of you. See, look at that. Hermit says, Sal says, don't feel bad for them because most of them will vote for the same people over and over again. It is hatred for Trump and ideology. So, Cully, go get your dinner. I kept you 4 minutes over, so I feel badly about that. I don't want to do that to you. I was going to ask you how you feel about Fat Beach Day coming to a beach near you, where fat positive women and men take over a beach for the day. I love it because then I just go find one and I go stand next to them down by the water, and I look good in comparison. So I was going to ask that as our non-political question to you, how you feel about Fat Beach Day.
Obesity is an epidemic in our country, and it's a national security problem because most military-age men can't even qualify to get in the military. And I work out every day because I'm a workout fanatic. It keeps me balanced. I think I'll be ignoring Fat Beach Day.
No, this is why you got to love it, because it's free therapy. It's going to make you feel good about all that working out. It makes me feel good when I can find somebody on the beach and then I go stand there, right? And so even though I may not be in great shape, in comparison, I look fantastic.
Yeah, I can't make fun of different people's body styles because I just not part of my religious beliefs. But I'm just not going to be celebrating days like that because that's not me.
No, it's all tongue in cheek. It's all in fun. As someone who lost almost 60 pounds, I can do it. I can make fun of it
Wow.
because I know you
That's
can lose. You can
that's
lose the weight if
awesome.
you want to.
That
Yep,
is
you can.
awesome. Congrats.
You
I
can
didn't know
lose the
that.
weight if you want to. So that's why I feel fully capable of pointing it out because these people go, I can't do it. Yes, you can. You got to get off your butt and you got to make better choices. And you can do it if you want to. So it's a choice in my book. Maybe for like 0.1% of the population, it's not a choice. But for the vast majority of the population, it's a choice. And I'm not making fun of them. I can't figure out if it's a good thing that they're confident because I know what it feels like to not want to go to the beach because you're fat. So I get it. So I'm kind of really torn about the whole thing. But I just thought it would be a fun last minute thing for us to talk about. So thank you so much, Cully. I really appreciate you joining us. You have a wonderful weekend and happy Independence Day to you, my friend.
Absolutely. Happy 4th of July to you and all the vets and those who've served our country in a variety of capacities. It's an awesome day.
And to all good Americans. Thank you so much, Cully. Enjoy your barbecue. Take
Thanks,
care.
Mary.
Thanks.
Appreciate it.
Bye-bye. All right. Thank you so much, everybody. Please like the podcast. Please retweet it. I'll get it all together. I'll put it up on Apple Podcasts and Spotify, along with all the information you need to get Cully, look for Cully's book and his writings as well. So I'll put it all up there. I'm going to try to do it today, but holiday coming up, so I'll do my best. Thank you. I did not get to put all your questions up on the screen because there was just a lot to get to, but I really appreciate you guys. And don't forget, I'll actually be on Newsmax 2 tomorrow on Todd Starnes' show around 5:25. And then I'm off. Oh, I'm gone next week. So I will not be on Newsmax on the Chris Salcedo show on Monday. I'm going to try to do a podcast Tuesday from vacation. So we'll see what happens. I'm going to give it a shot. We'll have to see how the internet is, if I can pull it off. Happy Independence Day, everybody. Thank you so much for joining me here on Mary Walter Radio. You guys are the best.